We are live. We are live, and you'll notice there's a new. Well, this is actually the second stream with the new addition to the live stream family. My Shure. Well, what is it? It's a Shure. What's the name of the mic? 7. Whatever. It's a new mic. Can everybody hear me and hear the wonderful deep bass of my voice and the sound of my mouth as my tongue smacks against the roof of a. Okay. We're not going to do any legal ASMR, although I guarantee you that would be a million sub niche in a month. You'll see Winston. I'll bring Winston down at some point tonight. Can't start with Winston because then everyone would get too distracted for the stream and we wouldn't know where to go from there. All right. How is everybody doing? How is everybody doing? Oh, also, incidentally, you'll notice there's a new sort of wider angle camera. So it's good. Echo. Is it working? Hold on. Nice mic. Sounds good. Okay. Don't mess with me, people, because I take it seriously and I'm going to think I didn't double check the knobs before this time. For anybody who was watching the live stream with John Carpe, it was on Thursday. And when John came in, I couldn't hear him. That's because I set the default speaker on my computer to the mic, which makes me an idiot. Anyhow, hopefully, let me just go ahead and turn down my email notifications just by quitting. So I won't make the same mistake again tonight. It really is. It's nice. It looks good and it sounds good. I think it sounds better. All right. It's going to be an amazing stream tonight. There's so much stuff. I'm going to get into my opening rant in a second. Let me just see. I missed a bunch of super chats already, and that's going to be the first intro. Mark Watson Square Hoop 1 said, like button smashed. Thank you. We got IT. Book question. I did say book review, and the Barnes smashed it last week. The question is, John Adams' mentor said, there's a good lawyer has a copy of the book of ethics and a copy of the law on his desk. Let me just see if I can actually find this super chat. Does Barnes have those books on his desk? Let's see. And I missed it. Okay. Here's a few dollars for Winston's treat fund. Funny enough, I did get Winston and Pudge bull penis, those long bull canes for them to chew on. And they've been devouring them. So it's great. Okay. Dumb question. Is it justified? Okay. Let me not read that so we won't get in trouble early on in this chat. Is it justified to end someone's life over a $20 counterfeit bill on site, or is it better to wait, follow home, get the printer, and prosecute them? We're going to talk about the Chauvin trial because if anybody hasn't been watching the jury selection, it's fascinating. I mean, it's fascinating. It's a glimpse that maybe we would have gotten it years ago, certainly not before the internet, but I think the interest is there now where lots of people are actively watching this. And you got Jack Posobiec live tweeting in real time, following it there on site and giving some of the most insightful real-time analysis out there. Okay, we got a good show tonight. I'm excited to get into it. Sure, making amazing microphones, that's for sure. Okay, so standard disclaimers. Thank you all for the super chats in advance. I'm going to miss some of them. If you're going to get angry if I miss your super chat, don't give the super chat. I don't like people feeling angry. Second thing, except for Brian Stelter on Twitter, who hasn't blocked me yet, but that other guy, the doctor, blocked me, but whatever. Second disclaimer. Wait, I haven't finished the first one. Super chats. Oh, yes. YouTube takes 30% of super chats. So if anyone does not want to support YouTube, but wants to support Robert and I, other ways to do it, just so you know that right off the top. I'm homesick, diagnosed with COVID. Thanks for making me feel better. True Vikes fan. I'm glad I can make some people feel better. I have been feeling a little frustrated these days. Frustrated, constantly on edge. My wife is a neuroscientist. I don't know if I told you guys this yet, but I'm saying this as a joke, but not as a joke. My wife is a neuroscientist, but I told her I've been having COVID dreams. I mean, I've been having them for 8-10 months now. And she said, it's an amazing thing. Your brain is literally getting rewired because of the external stimuli. Stimulation. Your brain is getting rewired, and it's getting rewired. We're getting reconditioned. It's an amazing thing. Have you ever heard of the laws of the mind, the law of attraction or law of association, etc.? A neuro-linguistic programming. No, but I'm going to look into it now. So while we wait for Robert, let me start off with my intro rant. Daylight savings time, by the way. So, everything's been the time has been bumped up an hour. So, what was 7 is now 8. That's right, spring ahead. Except curfew hasn't been sprung up as far as I know. So the curfew for COVID is not daylight savings compliant. And even though we have an hour extra daylight now, I don't believe, as far as I know, that the curfew law, which is now entering week 12 of the 4-week curfew, has been changed. I mean, I had the revelation, and someone remind me to tweet this later, that no one gave it's an amazing paradox that couldn't be more true, in that nobody gave the power to the government. Nobody gave the government all this power, and yet simultaneously everybody gave the government all this power. And it was sort of a revelation I had on the treadmill. It's gone. It's out of control, and I don't know when it got out of control, but in my humble opinion, it's out of control. And the hard evidence is only that we are now in Quebec, a year into this. We are in week 11 of a 4-week curfew, when our health director says that there's no concrete evidence to show the effectiveness of a curfew to stop the spread of a virus. But that wasn't the rent. Yeah, that's what I wanted to get to. The protests in Montreal and what has become of us. Yesterday, I actually thought the protests were today, and I genuinely, sincerely thought the I guess we'll call it a protest, was today. And I'm glad I didn't know it was yesterday, because A, I couldn't have gone regardless, and B, it's probably better that I didn't have the option of going in any event, because having seen the pictures coming out of that protest, I could have anticipated not getting into trouble because I would do something bad, but rather I would get in trouble because I would do something stupid, like try to ask a police officer the wrong question, or try to document in a way that might make the enforcers of justice, take the quotes out, the enforcers uncomfortable. Montreal looked like nothing shy of a police state. I mean, you had rows of police officers in riot gear, arresting people, clashing with protesters. And this is what Quebec has become. I posted a tweet comparing yesterday's images in Quebec to yesterday's images in Florida. And it's what freedom versus a police state looks like. And just today, I'm walking on the street, I'm playing on the streets, and I see a guy walking down the streets. He's carrying a sports expert bag, which for anybody who knows, it's like a sports store. And he had just purchased something, but that store is a distance away from where I live. So he had obviously walked from the store, was outdoors alone with his face mask. His glasses were fogged up to the point where he couldn't see. And he was like visibly irritated, uncomfortable, couldn't see where he was going. And, falling off the sidewalk, try to avoid us. And I'm like, this individual, there's could be no science to justify this particular context. Let me back that up a little bit. Maybe there is. Maybe this guy is the one person in the world who knows you don't touch your face mask, so he puts it on properly in the morning and does not touch it for the rest of the day until he gets home to wash his hands before removing it. Maybe he's the one guy that does that. But there could be no science that could justify this idea of walking alone outdoors, no one's around you, to the point where you can't see through your glasses. And it's just like, I could see it. He maybe I'm projecting, but he gave me the impression that he believes that he is suffering for the greater good, and that by suffering and causing himself to suffer, even though there's no any potential justification for it, he's somehow better protecting himself. And it's gone drip over the top. I mean, it's what it is. Chris Beatty, thank you very much. I mean, that is the rent. It doesn't go anywhere. It's just that it's over the top. And there's another March for Freedom next. I might go and try to document or live stream. Hopefully stay out of trouble and not try to ask people questions they don't necessarily want to answer live, but it's what it is. Okay. Alleged driving while impaired. Who was the eyewitness, and was the allegation nothing without evidence? I don't know what you're talking about. Alleged driving while impaired. Okay, hold on. I'm not sure what you're talking about. If anybody knows, let me know. Let's see this. Please don't take this not as a jab, Viva, but I must ask, why are you, with legal knowledge and a license, not fighting this in courts? I'm following them in courts. First things first, me in the courts as a plaintiff, it comes with, it has liability, it has baggage. So it would not be an ordinary plaintiff like the collective businesses who are suing. So you get me in front of a court and it comes with baggage. Second thing, I'm following them and I'm seeing what's happening to them, and they're not going anywhere. I haven't checked the actual lawsuit, the reasoning, but the Hasidic community of Montreal was in court last Friday not to try to over curfew, just to try to extend the curfew to 9:30 so that they could practice their religious beliefs. So the Hasidim can because it interferes with Shabbat. So to extend it to 9:30 so they could practice, without impediment, and to increase the capacity of who they're allowed to have, how many people they're allowed to have in a congregation. From what I understand, the government increased the number to 25 maximum gathering. But from what I understand, did not extend the curfew, did not extend the time at which the curfew starts. Gatineau, the judge says no go, because when you go for a safeguard, an injunction, a judicial review on an interlocutory basis or an injunctive basis, there's a presumption of validity of the law, and you have to show a substantially irreparable harm. And what's the lawyer who argued this said, my harm is that I'm not free. And the judge said, so you can't go out after 8 o'clock. What's the big deal? And on an interlocutory basis, dismissed the claim. I've seen the way it goes. So the issue here is there may not be a judicial one for a long time. I see what the Justice Center for Constitutional Freedoms are doing across Canada. John Carpe, I interviewed him twice now. Is doing the fighting that needs to be done, and in the way that is the best way to do it. But it's going to frustrate people because it's going to take a long time to get results. But that's it. I don't think the courts are going to step in. I've seen the way they're not stepping in. So what I think is probably the best way to do this, to express your discontent in the most vocal way possible, get as many people to know about this as possible so they can protest in their own respective ways, in the way that they feel comfortable doing. And you vote these people out of office the next time there's an election. And I know people are disenfranchised, or what's the word? Not disgruntled. What's the word? Discouraged. I know people don't have faith in the electoral system anymore. But that's it. Vote them out. And the other big problem, I am shocked at how many people support these measures and have no problem with them. And this is the problem when you create basically a government state. A lot of people have no problem with them either because they're very well off and they have the means. And I'm not excluding myself from that. I'm financially, I'm not suffering the way other people are, because who would have thought that making a YouTube channel would have been the safest business thing to do? Because I didn't have overhead. I have a few legal clients, but people have lost their jobs. But I'm finding that the people who support these measures are either very well off and don't have to worry about it. They're either in government and they're the ones who haven't lost their jobs, or they are now, in a way, the government's giving them more, or at the very least, the government's giving them less, but not much less than what they had before. So it's sort of, they can wait it out. But the entrepreneurs who have invested their life savings into their businesses and are losing this before their eyes, the people who can't exercise, the people who can't get their elective surgeries, they're the ones who are suffering. But there's a lot of people that are supporting these measures. Long-winded answer. Sorry, that's a long-winded answer, but to a lot of people supporting this, and you're not going to have neighbors fighting with neighbors, which is sort of what people want, I think. But Rocco Galati, Viva, I have never heard you vlogging on the Rocco Galati lawsuit. Why? I talked about it a couple times. The one problem is it's massive. It's impossible to break down in a vlog. It's 109. I've read it. It's 190 pages, like 400 paragraphs. It's massive. It's not the type of lawsuit I like to draft, because I think there's just too much in it for anybody to digest. So I would do a live stream with him for sure, because I think it would be undoubtedly easier to explore in a 2-hour live stream than to condense into a 15-minute vlog. So any day, I'm going to tweet out to Rocco. I'm going to tweet out to Gad Sad, because we have an opening on Wednesday. Sarah Silverman did not accept my Twitter offer. All right. Love getting the live stream an hour earlier after the time change, 4 p.m. in Arizona now. P.S. We don't change our clocks in Arizona. Keep up the great work, Viva. Okay. I see Robert in the house and he's looking good again. I didn't say what's on the menu for tonight. It's going to be great. I say they're always great shows, but shows. This is not a show, because this is just the world. George Floyd update. The jury selection. Are they overcharging George Floyd to the point where they might be securing an acquittal? Should Whitmer and Cuomo be behind bars? And not in the hyperbolic proverbial sense. abortion issue in Arkansas. I'm trying to think of a way that we can talk about an issue without incurring the wrath of YouTube, but we'll see. And control laws and more. So it's going to be amazing. There's so many things, and there's a Twitter lawsuit. There's the pastor getting jailed, which we'll talk about, but everyone saw that on Thursday. Sorry. Without further ado, 15 minutes in, let's bring on the Barnes into the stream. Robert, can I hear you?
I hope so.
Yes. Yes. Who would have thunk that the mic is not the microphone is not a good speaker for a computer? Robert, how you doing?
Good.
Okay. We're gonna plug locals right now because I just watched Robert Barnes's hush hush Q. What does QT mean, first of all? Down on the QT.
Quiet.
Okay. Now I know. Robert did a piece on the assassination of JFK. It's mind-blowing. It's mind-blowing how I think we have lost, the people have lost control of their countries to the government and government institutions, but mind-blowing. So anybody who wants, Robert is much more active on the locals with original content than I am. I give the sneak peeks to my vlogs, and I'm engaging, but Robert is just putting out amazing stuff. So that is the plug, vivabarneslaw.locals.com. Robert, what do we start with? I mean, I think the jury selection is just going to be fascinating.
It's an interesting week. This, of course, is March Madness week, so the local subscribers will get the bracket buster picks that I'll put out there, so you can beat your family, you can beat your hated employer, your neighbor, whomever, friends, but that you can have bragging rights throughout the year. That will be the goal. But they should finish jury selection this week, and the maybe we'll go a third week. The trial starts on the 29th. In the Floyd matter. A lot of things developed this week, so we got to see what some of the issues are.
Well, actually, let's talk about the jury selection, because it's an amazing thing. I did the vlog breaking down the questionnaire. Not much to it, but the questionnaire was not quite invasive. It was quite exhaustive. Asking what they think about Black Lives Matter, asking what they think about Blue Lives Matter, asking if they've ever had run-ins with the law, asking if they've ever been put in chokeholds, asking, everything, just to give an idea if they're going to be tainted. So the people fill out the forms, all of the prospective jurors. Do you have any idea how many people filled out the questionnaire in the first place?
We don't know. My guess, normally they call like 150, but I assume because of this potential jury pool, they probably sent it out to more like 400 or 500, because they're trying to pick 12 jurors, 2 alternates. And it was good that they did questionnaire. What's unfortunate is that most cases have no written questionnaire. And what we're witnessing by both the questions that they answered in writing that are being referenced in the jury selection in the voir dire, or how do you properly say it in the French?
Oh, voir dire.
Voir dire. Voir dire.
Voir dire, which is to see and say. Voir dire. I've been told I'm not
fascinating. So apparently that's old Norman French. According to at least the commenters,
and not Latin. Bygones, as we say.
Yes, exactly. But that was interesting. I like those little tidbits. But yeah, so from what they've disclosed already in writing, what they're disclosing in court, most of these jurors that everybody even acknowledges now, or most people acknowledge would have been problematic, who have been removed from the jury pool, would have been in a normal jury, because those questions never would have been asked. They never would have been asked in a written form. They wouldn't have been allowed to ask in a verbal form. Most courts don't allow lawyers to ask voir dire in the federal system. Some do in the state system, but it's sporadic in how many questions you get. Usually you don't get to ask the ultimate question in most cases. So a credit to the court for trying to do as much as possible to get an impartial jury. However, what the questioning is revealing and what the answers are revealing is it seems highly unlikely that is even possible in Minneapolis. I mean, what I would say is, one, the judge probably should have reconsidered his expanding the jury pool once he saw the juror answers. And the second, in the sense of going to a broader venue, you don't have to move the trial. You can just have jurors come in from more counties than Hennepin County, particularly maybe reach out to some rural counties. Aside from transferring the case for venue. That's what Rodney King case got transferred for venue. The Diallo case out of New York got transferred for venue. The O.J. Simpson case was kind of transferred for venue. It was downtown rather than the west side. And you generally find acquittals happen when you have jurors that don't come in with a prejudice against the defendant. And so far, most of the jurors are showing extraordinary levels of knowledge. And that's not a surprise to many in the audience, but it's a surprise to many of us who are lawyers, because in most cases, even high profile cases, you usually get 20-25% that haven't heard much about the case. To give you an example, in public opinion polling, 20% or so of the country has not heard about the case or has no strong opinions about the case one way or the other, which is usually a sign they haven't heard of it much. But what it is two things are clear. One, the social media effect, and second, the riots. The combination of the two, particularly in Minneapolis, means everybody has heard about the case. Everybody has an opinion about the case. And of the 7 jurors seated so far, 5 of the 7 appear to have already concluded that Chauvin is guilty of murder. And so that's a problem. And when your good jury is a jury that could reconsider their pre-orientation towards your guilt, that's not good.
Robert, one person said to tilt your mic up. I don't know if that makes much of a difference, but no, just to point it upwards, like angle-wise.
Oh, I can't.
Okay.
It's like this.
Sounds good to me anyhow. So this is an amazing thing. There literally is. There's not one person thus far who has been questioned under the voir dire who doesn't know anything about this. Like, they all know something about the incident,
and only one hadn't watched the video. So all the rest had seen the video. Many of them multiple times, and it was fascinating why they saw it. They saw it because of either the riots kept bringing the story into their social attention. And almost all of them didn't see it on the news. They saw it on social media, Instagram shares, Facebook in particular. So so that's going to be a big problem for, in my view. I mean, I think the judge is doing everything possible to try to create a fair jury trial, but it's just going to be uphill by their answers. The second part of the issue, now the prosecution clearly just wants a biased jury pool. Your job as a defense lawyer is to get the most pro-defendant jury pool. That's not the prosecutor's goal. The prosecutor's goal is supposed to be doing justice. The one group of people that are not supposed to be adversaries in the adversarial process are prosecutors. They're supposed to seek truth. They're supposed to seek justice, regardless of whether it, quote unquote, hurts their position. Unfortunately, we rarely see that, and we're seeing a bad version of it there, because they were wanting to put people on the jury who were clearly biased, who had clearly, aside from creating obvious appellate risk, which would be their deterrent, they clearly don't really care about getting a fair and impartial jury. They want a prejudiced jury that's just, they're just waiting for a jury to say, "Judge, where's the rope? And when do I get to tie it?"
Someone said jury number 2 will be a problem. Someone emphasizes science too much or says, "I believe in science," is a red flag. It's an amazing thing where we've been talking about it for a long time. Everything has been hyper politicized. And so certain tropes or certain expressions now themselves have been politicized to the point where someone's political orientation based on expressions they use, and you'll know how they're going to judge in this. One of the things that I found the most interesting is, I forget who it was. It was a 50-some-odd-year-old woman who had lived in Minneapolis or the area for her whole life, 40-some-odd years. She might have been 60. And she said that she was not afraid. She didn't fear for being a jury member. And I said, on the one hand, that strikes me as being grossly naive of anybody who doesn't know, how bad things can go on social media and how, especially in certain cases, it can materialize into real life. But then I think you said it when where did we talk the other day? Last week, where you said that's probably a good indication that a jury member is going to convict and not acquit, because nobody who convicts is going to be fearful, of the repercussions of having voted to convict, whereas the opposite to be the exact opposite.
Indeed, the prosecutor is striking anyone or trying to strike anyone who says that they're afraid of the consequences of their verdict. And at first I was like, I wonder why that is. Then it was obvious. The prosecutor knows that anyone that's scared of their verdict is someone who thinks acquittal is a possibility. Whereas anyone, as you note, that has no worries is someone who knows they're going to convict, because that's why they have no worries, whether they admit it to themselves fully or not. And so the fact that you have the people that are sitting on the jury are people that are not worried about what could happen to them, which is it's showing a venue basis. Now, if Chauvin's counsel is smart, what I would have done is I would have preserved the issue of venue transfer through jury selection and would raise it again and say, Judge, we now see we cannot get an impartial jury because he's got enough answers that, in my view, substantiate that. It looks like they're going to roll the dice. But I think that would have been a strategically sound move for Chauvin to make because of the problems we've seen. The fact that, jurors cannot vote honestly for acquittal without worrying about their safety and well-being is a major problem. Now they're trying to keep it an anonymous jury, keep the jury from names from being publicly disclosed. I don't know whether they're going to be fully sequestered through trial. That may be the case, but it was fascinating for people. I watched a lot of it. We don't know the written questionnaires other than what they bring up in court. So, and they did do a good job of going through the whole social media because of any of the jurors, and they had enough time to do so. So, like I said, this is the best version of jury selection that can happen. And yet it's disturbing because even then, a fair jury is a jury that's just not yet ready to lynch. That's not exactly a truly fair and impartial jury. And what you're right to is under the Sixth Amendment is an impartial jury. Now, people think of jury of your peers. That's a Magna Carta reference. That's actually not in the Constitution. There's no right to a jury trial of your peers. There's just a right to an impartial jury. But this is a jury that almost 5 of the 7, by my view, already believe that Chauvin is guilty of something. What is a different story. I thought there were 2 that were truly open-minded. I think if you probably 6 of the 7 voted for Joe Biden in the presidential election, and according to public opinion polling, that's a good proxy for whether they lean guilty or not guilty.
It's something we talked about in Roger Stone, because this is where one can get accused of sucking and blowing at the same time. In that, in Roger Stone, we were saying, it makes no sense to keep the juries anonymous. Where we can't, social media can't look into them. People can't do their due diligence to verify justice is occurring. The flip side here would be the risk is to say these jury members have to stay anonymous, because if they vote to acquit, they will get, they won't get doxxed. They'll have been publicly doxxed already. They will not be safe to vote acquittal, and so we have to keep them anonymous. And how do you balance that?
My view is it meant they needed to not have this jury trial in Minneapolis, because once you participate in the jury, you're a public participant and you're a public official. You're acting as a public official. You're with government. You're clothed with governmental power. And I've never been in favor of anonymous juries. I think they're high risk constitutionally. I understand the idea behind them, and they've usually been limited to terrorism cases. I understand why. I think here everybody has agreed, the court, the defense, the prosecution, to an anonymous jury. But the problem is people are allowed to take state action without knowing who they are. And I don't think that's a good idea constitutionally. I think that creates that undermines little d democracy. The way you solve that here is you have people that are going to be doing the jury trial in small town Minnesota, not in Minneapolis. The problem was picking a Minneapolis jury created this problem. So what it suggests, I'll have to look at it in the Rittenhouse case. It suggests a major venue problem, that the combination, if riots happen around a case or riots are there, the Rittenhouse is far less of an issue than Chauvin was in terms of its relationship to the riots. But it appears that riots highlight attention, and with social media make it so that there's almost impossible for anyone to know one way or the other, and now are adding a doxing risk. But you have to counterbalance that against the public interest in knowing who it is that's participating in government and deciding someone's innocence or guilt because of things like crowdsourcing information. Now, in Stone, it was ludicrous, because in Stone, there was no reason for them to fear anything. That they were afraid in D.C. if they voted guilty or not guilty. Not that many people cared about.
No, that's the thing. Stone was political, but not the same type of politics as this or as Rittenhouse. It was a non-violent crime as well, so it's much less of a victim type infraction in the first place. And there hadn't
been any Roger Stone riots. None of that.
No, and even still, like acquittal for Roger Stone for lying to the FBI, nobody cares about. An acquittal for this or an acquittal in Rittenhouse, and you're going to have the activists, for right or for wrong, up in arms about it, literally.
Yeah, it's definitely good lawyers from now on are going to need to test, focus group or test poll these issues. Social media is changing the game in a massive way, and riots have changed juror perceptions. So, because there were a lot of jurors who normally would have been probably Chauvin-leaning jurors who did not participate and will not participate in this jury because they recognize the risk when they vote acquittal. And so but it was disturbing to me that the government. I mean, it's not a surprise, but it's still this was an opportunity for the government to show the best of America's criminal justice process. The court is doing its diligent best to do exactly that. The prosecution is not. Mr. Antifa, Attorney General there, Ellison, who was a huge fan of Farrakhan, so that gives you a sense of where his background comes from. Who used racialized politics to get power in the first place? Who's brought in a dream team of private prosecutors? It's another sign. Next time you hear defense people or AOC or any of those people talk about bail or anything else, they don't care about those issues. They want their people out on the street. They don't actually care about constitutional rights to bail. They don't care about constitutional rights to jury selection. The entire legal left has forfeited any moral authority to ever again claim they care about constitutional rights in this context because they've refused to speak up for them either in this context or in the context of the Rittenhouse case.
Well, I mean,
it's problematic.
No, it's beyond refuse to speak up for him. I mean, I say politicians, not individuals, but the left in Washington want to go after, they're going after the Capitol riots with a sledgehammer, and they are quite literally dropping the charges with prejudice against Portland. The two are mutually incompatible, and that would assume that they were even mutually morally equivalent in the first place, which I don't think they are. But I mean, I'd say Capitol Hill was serious. The question is what was more serious. Let's just, even for argument's sake, say they were both equally serious. They're not getting treated both with equal seriousness, and that's a big problem.
No doubt. So I mean, they have a jury that kind of that's not a full-scale lynching jury because of the diligence of the court, but it's a jury that has some serious questions with it and about it. It leans guilty, but we'll see. We'll see how. Now, the second component of what took place this week. But for anybody, it's great to watch it. Watch how jurors answer questions. Watch what questions get asked. Most of this you'll never get to see, but it's how a jury selection process should work. And to credit to the court for doing the best possible to fetter out. Like, the court did a great job of protecting the presumption of innocence, which a lot of judges don't do. This judge, he figured out when someone was really saying, Chauvin's going to have to convince me he's innocent because I presume he's guilty. And by the way, the prosecutor anxious to put people who presumed the prosecutor wants a lynching jury in the Chauvin case by the kind of evidence it wants to present and the kind of jury selection it is engaged in. Even raised a ridiculous reverse Batson challenge. And for those who don't know, Batson is a case that says you can't racially discriminate in your jury selection process. At least the state can't. They've later extended that to the defense side of the bar. It was clear that the prosecution does this all over the country all the time. It's usually the prosecution who's engaged in questionable conduct. Here they're accusing the defense of doing so after only 2 people were struck. And the 2 people that were struck, it was obvious race had nothing to do with how they were struck. Indeed, this jury pool, though the media has tried to hype how many white people there are on it, this is Minnesota. This is Minneapolis. This is a overwhelmingly white state, overwhelmingly white city. It has an unusually high number. I think right now, 3 of the 7 are either Latino or African American. That's above the population percentage in Hennepin County, not below it. Now, it's fascinating to watch watch the press hype this, because back in my Snipes case, where they deliberately rigged the jury pool to make sure it was literally all white, the media, a lot of the media was just completely quiet about it. Never seemed to get around to mentioning it. But here, every other headline is how many of them, oh, look at all the white men on the jury. It is a male, right now of the 7, it's male to female, 5-2. It's also an unusually young jury. So, I don't think there's not a single retiree, which is unheard of for a jury pool. Also, that usually, you look demographically, this looks like a hang Chauvin jury for the most part.
Especially the younger age, the fact that some of the questions they had asked, I don't know if these jurors or potential jurors got struck, but do you support what did they say? Do you support the damage caused by the riots, and they said to some extent, if the ends justify the means, something along those lines. But
all of these are pro Black Lives Matter jurors. Most of them, I don't think any of them are really pro Blue Lives Matter because they were asked those questions. So that gives you a sense that that's not proportionate to the country, and nor is it even proportionate. Now, Minneapolis, overwhelmingly Democratic city by 4 out of 5 jurors would be expected to be Democratic voters. But this is even more so than that, as far as I can tell. Now, again, we don't know as much information as they know because they know their names. They've been able to run them up, so on and so forth. But the only thing I would say is, in terms of other things, jury selection, we don't get to see who's sitting at the prosecutor's table, but it didn't appear there was any jury consultant amongst their group. They got all these bigwig lawyers, private counsel they brought in, hired guns to prosecute this case. Extraordinarily rare. But it didn't appear they had a jury consultant at the table. It appeared maybe the defense had one, but they weren't paying attention to the body. I was watching. They didn't appear to be paying attention to the body language of the jurors. Now, it's a little bit hard because they got all this glass and masks and where they're seating. But, you would want a good trained body language expert like the behavior language panel, which did a great breakdown of Meghan Markle and Prince Harry. Meghan Markle is, in fact, a narcissistic liar, like I thought. But it's always great to see the experts confirm it. And Prince Harry's stuck in a 12-year-old body or 12-year-old brain. And both, great breakdown for anybody who wants to watch that. So about 2 hours long, but it's fantastic. But you want that kind of analysis there. They didn't seem to have that there. So it appears they do know their social media profiles, know a lot about them because of their answers to their questionnaires, are a very Democratic leaning juror, fit demographically the partisan affiliation and age of, and even to some degree being, African Americans were much more pro conviction than whites, at least in the public opinion polling concerning Chauvin. Given the representation, and same with Latinos. So it looks like a jury that's going to be bad for Chauvin, despite a lot of really smart efforts to try to get the best possible jury, which shows you how tainted the Minneapolis jury pool turned out to be.
Okay, now one question I forgot that we talked about this with Cernovich on Wednesday, so some people might not have heard some of the stuff that we said then. So we'll get back into it, but. One question was, someone asked, why do you think it's important to know the identity of the jurors? And so answer that as we get into the question as to how this record-setting $27 million settlement reached and announced on the eve of the trial during jury selection, what impact that's going to have on the trial. But starting with the juror selection, why do you think it's important? We've talked about it before, but refresh everyone's memory.
Sure. I mean, it's critical for the public to know who's making decisions about innocence and guilt. So imagine if you didn't know who your president was. Imagine if you didn't know who your senator was, didn't know who your mayor was, didn't know who your prosecutor was, didn't know who your judge was. That's what a juror is doing in the case of determining the guilt and innocence of an individual. And so it's important for you to know who that person is so that you can have public, response, in my view. And then the second part is for crowdsourcing information. Much of the information about problematic behavior by jurors only comes about because their name is publicly known. You can't expect the lawyers by themselves to smoke that out. It just doesn't happen, particularly if it's hurtful to the defense. The defense does not have the wherewithal or resources to be monitoring every single juror's social media page, to do so in a way that doesn't trigger any problems professionally. Because you can't be communicating with them once they're selected, for example. So there's all these kind of issues present, whereas if it's publicly known, then that information comes out. So you get more transparency in government and more functioning of juror democracy. The problem isn't that that they feel a need to be anonymous in order to have an honest verdict. The problem is an environment that creates that need in the first place. That's the problem. And so it raises, to my view, is if you can't have a public trial with publicly known jurors in that location, then you can't do the trial, period. You have to do it somewhere else or you can't do it. I mean, that's a problem created by the rioters.
Actually, that's an interesting question. What is the alternative if you just simply can't have a trial? It's not a mistrial, is it?
They've never said that, of course.
Okay.
So that's my opinion, but it's not one that any court's going to enforce anytime soon.
Okay, so there has never been a case where it has been so impossible to hold a trial that they have not held a trial.
Correct. That's correct. I mean, they try to do secret trials instead, which is what, like I said, a bigger problem in my view, or creates its own set of problems. Now, what they could have done is transferred for venue. And there were people asking about this. They did move to transfer for venue. The court denied it. They also moved, my understanding is, to have a broader jury pool. That too was denied. The problem here was twofold. One is the U.S. Supreme Court in the Enron cases greenlit the absurd selection of Houston in the Enron cases, despite the inflamed anger towards Enron in that community and in that jury pool. And once the Supreme Court approved that, no court's going to move a trial unless you have overwhelming evidence of problems. And that's why I say I would have preserved it for trial, shown the judge the problems, and used it either as leverage to get a much more impartial jury pool or to have the judge reconsider his original ruling. But the other problem is that this particular case was nationwide. So where could you move it? Now, in the northern part of Minnesota, they're not going to be worried about people tracking them down in rural northern Minnesota in all likelihood. There'll be some, but nowhere near the people who live in Minneapolis. The parts of Minnesota who experience no riots don't have anywhere near the same fear level, quite reasonably, as those do in Minneapolis. Now, the prosecution didn't want that because, again, the prosecution wants a lynching jury in the Chauvin case. It's a peculiar way to prosecute what you consider police lynching, how some people have described what happened to George Floyd, by lynching the person you think is the defendant. But that's very much the approach of the prosecution. They're trying to introduce evidence that's clearly inflammatory, unfairly prejudicial, irrelevant. But how they behaved in jury selection was sadly revelatory of the degree to which this prosecution will go to rig the outcome.
All right. Now, speaking of rigging the outcome, what do we make of the $27 million settlement? First of all, the quantum. Second of all, the timing. And third of all, $500,000 of that settlement went to, what's it described as?
That George Floyd Square community, I think.
George Floyd Square. So, I mean, okay, $27 million, from what I understand, is a record in and of itself.
At least in Minneapolis. There's a few other cases that have gone higher, but that is it. To give people an idea, a typical wrongful death case in the United States settles for six figures, usually low six figures. So I don't like these cases because it gives people crazy impressions. So you get jurors that think that all these cases are about crazy verdicts. You get potential clients who say, where's my $27 million? This was a political payoff. The timing of it is a little odd. To do this right in the middle of jury selection is problematic. Now, all these jurors are not supposed to have read or reviewed or heard any media about the case since the summer. How realistic that is an open question. It does create an issue. Once jury selection has started, you can argue for a mistrial. You may see that by the defense. It does create a problem, the timing, but the amount is nuts. Maybe a Minnesota jury would have awarded this, but the highest. I'll give you an example. My client was the biggest recipient out of Milwaukee, and that's now public information. And it was over $2 million. That was the highest amount in Milwaukee. It's not that different from Minneapolis. $27 million is, and frankly, far more egregious facts than are present here. It's really it's a payoff, but people should take that into consideration whenever they're assessing what Ben Crump and other lawyers like that are doing. By them promoting a certain narrative, they're lining their pockets with they got millions of reasons to tell a certain story.
In the industry, what would be the percentage that Crump or any attorney? A third.
So he probably got $9 million. And this is on top. He's Breonna Taylor, Mike, a bunch of other cases. So he's made millions off promoting this narrative. Millions. And the media loves to promote that same narrative. He gets rich. The media gets the political agenda and the ratings they want.
We got $500K for George Floyd Square, which is now a declared autonomous zone like CHOP. The city voted for this.
Yeah, unanimously. But you can see the fear factor. Honestly, it's also another bad sign. There should have been at least like one dissident vote. The timing of it, the amount of it, the refusal to question or challenge it. Taxpayers are going to pay that, by the way. That's where that money comes from. They usually have insurance policies, but not $27 million one-person insurance policy.
Yeah, the cap on an insurance policy would be $2 million, $5 million max.
Yeah, something like that. And an insurance company wouldn't have greenlit this size and scale of settlement in all likelihood. And to give people context, That's the annual budget of the entire Minneapolis Police Department for 3.5 years. That's how much money this was.
That's mind-blowing. Okay.
Completely. So we'll see. Now, it could have a positive effect for Chauvin because people may say, all right, Floyd's family got some justice. It may mitigate the feeling that they have to convict here in order to get that justice. If in fact they discovered it in that manner. So
that's an interesting point. They might feel less guilty acquitting in that 27 million. There'll never be justice one way or the other, regardless of how you feel about this. But at the very least, they can maybe justify that. The civil settlement. First of all, I'm sorry, I didn't realize this. I forgot to mention it. We're simultaneously streaming to Rumble, and apparently 2,500 watching live on Rumble, which is nuts. By the way, that's nuts because we're still in the beta phase, or they are still in the beta phase. There's no commenting there, but you can watch it there, and apparently the feed is better. I don't know how that works, but I've been told. The 27 million to the family. The question is this: the settlement will be, whether or not the jury members know or learn about it now, it will be brought up during the trial. Sure as sugar.
No. Oh, in fact, here's the evidentiary rulings. Nothing about the settlement will come in. Nothing about George Floyd's past is coming in. Almost nothing about Chauvin's past is coming in. So all of that is being systemically excluded. Some of the crazier things the prosecutor wanted, which is it's clear more and more what their storyline is going to be. Their storyline is going to be all the people that were warning Chauvin at the time. I think a firewoman, the woman who worked for the fire department who came over, the guy who knew MMA that was on the scene, other people's statements, plus the other cops who were saying, what about turning him over? It's clear that's going to be their narrative, but they wanted to introduce patently prejudicial evidence. And for people to know what that term means, it's when the evidence is unfairly prejudicial, unduly prejudicial. We, in our legal system in the States, do not want people to make decisions based on what we consider emotions. You can argue whether this is practical, but this is the theory. We want them making decisions based on reason and logic and facts. And consequently, if evidence is likely to inflame an emotion to such a degree that it will contaminate the reasoning process, then that's the evidence we want to exclude under what is usually Rule 403 and the federal rules. I think it's the same in the states, but some states have different numbering systems. And it's whether it's unduly confusing or unfairly prejudicial more than it's probative, more than it's, is it likely to contaminate the reasoning process? The prosecution wanted to introduce evidence of these people's opinions, of the fire person's opinion, saying, if he would have done what I told him to do, Floyd would be alive today. And the same with the MMA guy. And they wanted a third person, an expert, to testify using the word lynching as it related to Floyd. So this is absurdly inflammatory evidence. The judge was agitated it was even being sought to be introduced, but it tells you the mindset of the prosecution. They are going to go all out. It wouldn't surprise me if the prosecution puts up fraudulent evidence that's later proven to be fraudulent. They are clearly willing to do whatever they have to get as many convictions as they can. And they don't care if it gets reversed 2 years from now. They don't care if somebody figures out they were corrupt 3 years from now. They're doing whatever they can to create an atmosphere where they can get a legalized lynching of Chauvin. And again, if you have confidence in your case and you believe in the justice process and you care about appellate risk, you shouldn't be doing any of these things because you're like, look, I got an open and shut case. I'm not going to take any gambles. I'm not going to have any risk of anything that could go sideways on appeal, could go sideways in the court of public opinion. Just going to present my evidence because it's so compelling, so persuasive. If I was the prosecutor, I would have picked a jury outside of Minneapolis. I would have been said, look, the evidence is so strong, any reasonable juror that has nothing to do with this case, has no connection to this case, will make a fair judgment. And the fact they don't care about any of it is emblematic of a lot of our prosecutors these days, but still disturbing given the high profile this case has and what people will learn about our justice system through it.
All right, so moving from this, I guess this is a good segue into the other issue as to the charges now. So the third charge against Chauvin, which was third degree murder?
He was charged with second degree murder, third degree murder, and second degree manslaughter.
And it was the third degree murder charge that was initially dropped The Court of Appeal said reconsider it. I guess the judge reconsidered it and has now re-added it to the 2 other charges. So he's facing the 3 charges.
Which doesn't make sense. Dershowitz put out a video where he agreed with me. So maybe he's watching the show. I'd just like to say Dershowitz agreed with me.
No, there were a few people in the chat who did not agree with your take on the felony murder not making any sense under Minnesota law. So people are taking issue with that. That's what the discussion is for. And what I just love is a little parentheses is that when people disagree with you or other people in general, it automatically becomes a question of they're lying, and they know that they're lying, as opposed to Robert might just believe something that you don't believe, and you may have your reasons.
But Dershowitz had the exact same opinion I did. In fact, he thought it was kind of absurd that a 2nd or 3rd degree murder was being charged in the case. But as an example, I got a little prop, Garner's Dictionary of Legal Usage, that has its old history about definitions of murder, has all the old legal documents in it. And it talks about homicide, what homicide is versus manslaughter. And they say homicide is when or murder is when you have the unlawful killing of a human being with malice aforethought. That's the great old language. Whereas manslaughter is where you commit homicide, but without malice aforethought. This is the oldest understanding of murder and versus manslaughter. And yet he is being charged, even though they admit that there was no malice aforethought. That's why they didn't charge 1st degree murder in Minnesota.
Well,
so it shows how a joke it is. The idea is you have malice aforethought if you're committing such a dangerous. In fact, the same book goes into the idea is you have different criminal culpability based on different levels of criminal intent. So there needs to be differences between the 3. One of the 2 points that Dershowitz reinforced as well, which is the rule of lenity and the need for separation of criminal responsibility and criminal statutes, also reinforced his interpretation, aside from just the plain language of the statute and the constitutional and common law interpretation of these statutes, which is that 2nd degree murder is when you're committing such a dangerous felony that you can be held responsible at a higher level when a death takes place. The same with 3rd degree murder is when you're behaving so recklessly. He actually used almost the same analogy I used, which is that, you're shooting randomly into a crowd. That's that's why the statute itself says others, not other. When you're being eminently dangerous to others, then your behavior is so extremely reckless that we can hold you to a higher degree of responsibility. 2nd degree manslaughter is when you're being reckless toward just one person. And the Court of Appeals has said, nah, even though the jury instructions have always said that, we're just going to throw that out. We don't like that. Politically inconvenient. And they told the judge, you got to reinstate it. The Minnesota Supreme Court did not make a ruling. The press tried to pretend that they did. The Minnesota Supreme Court simply did not take up the case pre-indictment. What they're setting up is a situation where they can get convictions. They're hoping they get convictions on all 3 charges, get a big PR win. 2 years from now, the Minnesota Supreme Court, if they're doing their job, come in and say 2nd degree out, 3rd degree out, and he's back to 2nd degree manslaughter and ends up doing little time. Less time probably than he would have agreed to plead to. So that's what I think is being set up to occur. They want to momentarily satiate the crowd, make it look like he's been lynched. And then if the legal system steps in later and does what's correct, what they should have done in advance, then they may correct it and remedy it ultimately. But I don't understand. Neither one of these charges belong in the case. They're classic overcharging. They're abuse of the prosecutorial process. If you cared about PR, they create undue exposure for acquittals. Dave Rubin and others expressed concern that any acquittals might be played by the press as the lead verdict, and that could trigger another round of riots and looting. I think that is a serious concern. I mean, they're creating this is a 2nd degree manslaughter case, and they have evidence to support them. There's evidence against them. And why not just keep it at that? But they can't, because they want a lynching verdict.
The question is this, though, the settlement coming in now, call them arguable overcharges, potentially the 2 more serious charges to the 3rd. Someone in the chat had mentioned earlier that on information and belief, they might be setting this up for a guilty plea to one of the lesser charges. So there'll be jail time.
He already offered to do 2nd degree manslaughter. He already offered to do longer term than normal. They turned it down. In fact, Attorney General Barr made sure he was going to do a state and federal combined deal. Attorney General Barr is the one who quashed it. So it's another one of Barr. Barr may go down as one of our worst attorney generals ever.
Okay, this is news to me, and I don't know if it's going to be. If it's news to people, everyone watching, put in a little why. Chauvin agreed to plead guilty to second-degree manslaughter.
Yes, and do basically a stipulated sentence of 10. Is my understanding of 10 years. So which is the norm is 2 years in Minnesota on is my understanding. You can serve up to 10, but normally you serve 2 to 3. Now, again, Chauvin has other problems. Chauvin has tax problems, probably corruption problems. That's why even if he got acquitted of everything here, he's going away. He's got no chance. They'll probably tag on federal civil rights charges like they did in the Rodney King case if, in fact, he gets somehow acquitted of everything here. So he knew that there was no chance he could survive this onslaught. He just didn't want to go in for 20, 40, 50, something like that, 20 or 40 years, that being the other risk. And so he agreed early on, and they could have calmed all of this. And think about how much that could have helped calm things for Trump politically. So, Barr sabotaged Trump over and over and over, and sabotaged the country over and over and over, and sabotaged justice over and over and over. But it relates back. You can't trust a guy whose daddy hired Jeffrey Epstein and gave him his first job. And remember, everybody, 3 eternal truths. Number 2, Epstein didn't kill himself. And that also happened, by the way, under Attorney General Barr's watch.
People are saying you mentioned it last week. I swear to you, I would remember you having said that Chauvin agreed to plead guilty, but maybe
it was just briefly mentioned.
Okay, why is it news to people? If Barnes said it last week. If he said it, I missed it, but so did a lot of other people. So I feel less guilty.
Yeah, no, very short.
Had I heard that, I would have retained it for sure, because that's the idea that's very interesting, and also potentially a win-win as opposed to avoiding a potentially disastrous lose. Okay, so I mean, what's the next step now in this? Jury selection should end sooner than later. They need why do they only need they need 12 and they have 2 alternates? Is that the typical number that you go for in a criminal trial?
Yeah, I mean, to some degree, it's constitutionally required if it's a felony. The Supreme Court overturned these small juries that they were trying to do in criminal cases either last year or the year before. So normally the norm is 12, and you normally need at least 2 alternates, because if something happens and you end up with fewer than 12, mistrial, case over. So that's why you need the alternates for. Now, different case. Sometimes the alternates know they're alternates. Sometimes they don't. Sometimes the lawyers and everybody knows who the alternates are. Sometimes not decided until the end of the case. So I prefer the protocol where it's not known until the end of the case. But also totally weird courtroom layout. The defendants are going to be facing the jurors, which almost never happens. I mean, looking right at each other. They're trying to do social distancing, so they've made the jury box 3 times larger than normal, which is going to be, you're going to have these jurors sitting way back here, and then all this glass. You're going to hardly be able to see any body language of the witness. And if they require the witness to wear a mask while testifying, apparently they're not going to necessarily do that. But that would make it even more so, where they were having speaking problems, because whenever even the judge had the mask on, people couldn't hear. It's all going to be live televised. And again, I think it's very interesting for people to watch. It shows what a jury selection looks like when it's done well, and show the advantages and disadvantages. I thought the defense lawyer in general is doing a solid job. I would be arguing more in the court of public opinion because of the ways that impacts the case, but that's just my style. To shape the media narrative so it's not so hostile, because clearly that keeps leaking back in to how the judge and the courts perceive these cases. But fascinating to watch. And it'll take all week. They took all week this week to seat 7. Yeah. So this week, and it's because they're doing motions in limine. For people who don't know what that means, that's pre-trial motions to resolve certain evidentiary issues before the trial starts. Chauvin may still move to continue on grounds of the reinstatement of the 3rd-degree murder charge. I think he said that he's not going to, but you can always leave that option open. Other things can happen. There's other evidentiary issues that are getting resolved all week. So there's a mix of time between juror time and the rest. I think they'll pick the jury by the end of next week, but he's afforded a whole 3rd week in case they need it, because you never know if you just start running into jurors that are bad. So but it was fascinating to listen to people. It was very revelatory. It's a very impactful case, but also just good to see how the criminal justice process can work and it will be one of the most interesting cases to watch since the O.J. Simpson trial.
Someone had said that televised trials are a joke. I think the exact opposite in this particular case. This needs to be televised, and people need to, if not watch it, have access to having watched it in order to be prepared for the outcome when it comes. And regardless of which way it goes, it's just, this needs as much exposure as humanly possible in order for people to know what might be down the pipeline. Okay, what do we say? Do we move on to second subject?
Yes.
The second subject of the evening.
Well, speaking of real criminals who belong behind bars, dear Cuomo and Whitmer, both in the news this week, and something that I've been talking about was confirmed by Jack Posobiec and some other people this week, which is that Kamala Harris is behind the political takeout of Cuomo, which is why the stories will keep mounting. And also, I'd mentioned last week with Richard Barris and People's Pundit, the What Are the Odds show that's on Mondays, that if I was right about Harris, watch for other potential people to be on the list next, other than Newsom and Cuomo, who've clearly already been on the list. And then the news of Whitmer broke. Now, there's always been problems with what Whitmer's done, but what the reason why all of a sudden these people are being looked at, in my view, is because there are key Democrats who want them removed from political competition. That doesn't change the fact that they committed far worse crimes than what the former governor of Michigan was charged with doing.
It is amazing because, first of all, how does Posobiec get his intel? I mean, these are trusted people just telling him stuff behind the scenes that he can then disclose to the world.
Used to be in defense intelligence, so leave it at that.
Okay, so Posobiec, I mean, I imagine everyone watching now knows.
I don't think they've found a single story he's broke to be wrong yet in 4 years.
He's someone to follow on Twitter for those who don't already follow him. And yeah, it makes sense when he mentioned that about Kamala Harris. Someone tweeted out, "You had been saying this for a long time." I don't appreciate these things, and now I appreciate them. It goes from first to Cuomo. Whitmer, who had aspirations, from what I understood, of potentially being the first lady, the VP, and was snubbed despite her own things, which we'll get into in a second. And it is interesting to see now, no honor among scoundrels, where they're all turning on each other for serious things and things that are less serious but serious nonetheless. But so I mean, Whitmer, the executive orders. I mean, the whole issue is Whitmer has the same type of. It's the exact same history as with Cuomo. They issued these executive orders. I made a joke in my video talking about it that they were so inclusive. They didn't want to exclude patients, based on testing requirements or testing results. So these nursing homes were required by executive order to take back COVID positive patients or patients who were not tested but still infectious by all accounts. And it led to what it led to. And they renewed these executive orders. It was May through September. This is a long enough time to know what's going on. How are they going to face charges? What charges are they going to face? But how likely is it? And I mean, what's going to be the basis for the charges themselves?
The easiest place to catch him is apparently that Whitmer repeated Cuomo's easy to catch mistake of trying to doctor the numbers and hide the information. So that will be the easiest place, because they knew what they were doing was killing old people, and they didn't want anyone to know, and they definitely didn't want the Trump administration to know, because they need to keep building a certain narrative that, orange man bad, we good. And instead they were taking actions that were deliberate, and they kept doing these things after the CDC said not to do so, clearly said not to do so. And they just kept doing it anyway. And so I think it's the easiest place. Now, I think it is it's far worse criminal negligence than what they prosecuted the governor for what happened to Flynn. So that's the standard. Then the Democrats got to set that standard. Number one. Number two, they likely fabricated information or hid information or did fraud in the document part of the process. And that usually violates state and federal law, depending on where they did it and how they did so. So I think they're both in serious trouble. And if I'm right that they're on Harris's hit list, then they're probably DOA. Just don't know it yet. And then, of course, the other thing is you documented, and as we talked about from the inception, everything about that Whitmer kidnapping case smelled like government entrapment, and there's more and more evidence that's exactly what happened.
It smelled It smell. I mean, you said it. I can't take credit. You said it look because I don't even have experience in criminal prosecution or criminal cases. It smelled like entrapment. It smelled like a very convenient story to be breaking at the time to paint someone who had been demonized by the media in the most sympathetic light. And you know the story. It's the orgy of evidence from Minority Report is like, how often does this happen? Where you have just a perfect, what's the word, confluence? You know, a perfect coming together of all of these things at a perfect time, coming from, you know, coming at a person who herself arguably threatened the president of the United States in a public address. So it's amazing that one of the three informants, who, from what I understand, was in fact a paid informant. I'm nervous about saying something that's not true because all of these articles, you know, refer to the informants, some of whom were paid, one was not, and you don't know which is which. But from what I understand, this particular informant was a paid informant, was one of the three, egging these four other guys on to, you know, engage in this plot. And now he was indicted by the FBI on illegal possession of a 50 caliber sniper rifle, which I don't know what it looks like, but doesn't sound good. And I saw, if you can believe this, I'm not going to name the name because I don't know who the lawyer was, a lawyer in one of these mainstream media articles trying to spin it as a positive. It literally said, well, this lends credence to the plot then. That the dude who's the paid informant to set this all up is in fact potentially the only criminal in this. It doesn't bode well. But I mean, what's your take? It's a no-brainer. This is not good.
No doubt. I mean, I think that as they dig in, that's what they'll find. The case is, I mean, they had a bunch of people who were public on the internet, kind of ne'er-do-wells, talking out of their mom's basement. And they, you know, a bunch of FBI informants infiltrated their group, talked them into doing something dumb and crazy that never actually happened. And then they accused them of this big conspiracy plot to kidnap the poor Democratic governor, almost like it was a preview to what was going to happen on January 6th. In other words, that certain ideas were being planted into the public of these scary, dangerous Trump supporters or lockdown critics out there. For that, people can watch the first Hush Hush that's on Viva, barneslaw.locals.com and see how much of it has already come true. But I think that this case is going to continue to unravel as discovery unfolds, and we'll probably see it die a quiet death. The media won't cover this part of it like they covered the first part of it. That's my guess.
It was mine. I mean, it's ridiculous because things just happened so, you know, well into it, where you had talked about it quite literally. We went over this in the early stages. It was too too convenient, too perfect, too timely, and now it seems to be falling apart despite the media's most positive spin from the media that's actually reporting on it. Because if you Google it, you're only going to find 2 or 3 articles on it. One does not come from a reputable source, and the other one is quasi-reputable. And no one else is talking about it. It's like it's not happening. Mind blowing.
No doubt.
So Whitmer, I mean, what's the time frame if they do go after her? If they do, what do they do? Indict? Do they press formal criminal charges? Do they move to impeach? She is the governor, so she can be impeached. Correct?
Yeah, they probably, like Cuomo, will move to impeach. There'll also be parallel federal criminal investigation afoot. And there'll be state criminal. Apparently, this gives you an idea for who might be behind this, is that the Wayne County DA was announcing involvement. That's a very Democratic county, but it's people that I think if people dug deeper, they would find people that are allied to Kamala Harris, and that they're saying they're going to use their prosecutorial powers to take him out. So but in this case, I'm happy. I don't care what Harris's motivations are. I would be happy to see Whitmer and Newsom and Cuomo be out of office and out of power and disgraced as they deserve to be.
I believe there's a fourth that we have to add to the list. Is it Wolf? Is it Pennsylvania did the same thing?
They probably won't go after. Here's the thing. Wolf and Evers, Wolf from Pennsylvania, Evers from Wisconsin, have no national ambitions. So watch those two somehow dodge problems.
People, you heard it here. You heard it tonight. 1 hour, 8 minutes into this. We'll see who gets prosecuted and who doesn't, or who they go after. It is amazing. Like you say, even if the prosecutorial process has been politicized, where typically we've seen this materialize by going after the right and Republicans and whatever. Well, it is interesting to think of it as they will use this weaponized political prosecutorial system to go after their competition as well.
Ask Leon Trotsky how all that turned out.
Okay, that is phenomenally interesting. And let's see. We'll get to that in a second. What do we do now? Whitmer, Cuomo.
Well, I mean, transitioning into some crazy legal actions, probably Texas versus Twitter, which you know the good summation of.
Yeah, well, so I haven't done the video on it yet. I read Twitter's they're trying to take an injunction to get Paxton, Attorney General of Texas, to stop investigating them. For those of you who don't know, Attorney General Paxton said he was going to look into censorship and bias in big tech, and he issued the acronym is a CID. It is a Civil Investigation Directive. What's the third letter?
Basically, it's a
subpoena of sorts.
Yeah.
And so Paxton issued a subpoena to like an investigation type document request to say, we want to see how it is that you go about moderating content. Twitter files a lawsuit, an injunction to prevent AG Texas from doing this against Twitter on the basis that, they've complied enough and it's a private enterprise. They are entitled to exercise their First Amendment rights while preventing others from exercising their First Amendment rights. This is essentially the injunction action that they've taken against Texas. What's the state of the suit? It's just been filed.
It's just been filed, but it's extraordinary. It shows the arrogance of big tech. That big tech's like, you can't investigate us. We don't care if you're the Attorney General of the state. We're Twitter. And the fact they ran to the courts so quickly tells you where they think their political protection is. They think their political protection is now at the federal government level and especially in the courts, that they would be somehow so above the law that they couldn't even be criminally investigated for potential criminal conduct, while at the same time arguing they have Section 230 immunity such that they can actually publish CP because they're being sued for that in California, while at the same time bragging about their right to censor people in general. It's a combined, the level of arrogance is extraordinary. It makes Meghan Markle look humble by comparison.
Well, I'm going to say now arrogance and arguable, more lack of self-awareness, in that they literally in the lawsuit allege they as a company have First Amendment rights, and Attorney General is infringing on their First Amendment rights by attempting to investigate how they're exercising them, and that their First Amendment rights empower them to censor other people's First Amendment rights, all the while they benefit from Section 230 immunity. And what I especially loved is when they responded to the accusations that there's a conservative bias at Twitter. In the early stages of the lawsuit, it says there's no conservative bias at Twitter. Trump, when he was on, garnered tens of millions of followers right up until they censored Trump. And then they get into their justification for censoring Trump, and they say, we interpreted his tweets as potentially inciting further incitement, violence, whatever. And our decision was so justified, and look how justified it was. Google and Facebook did the same thing about the same time. And they're basically flouting that they are more powerful than the government, that they have, call it an antitrust cartel. Well, I want to call it a cartel now. They have a cartel, and they judge the legitimacy of their own action based on what their cartel cohorts are doing. And it's like this self-fulfilling prophecy feedback loop where they say it was justified because they did it, and they did it because it was justified, and you can't investigate why we did it and how we did it. It's crazy. I just don't know what the outcome is going to be, other than that injunction gets dismissed.
I don't think I've ever seen an injunction like that issued. It's usually you can't even bring them. Usually they're dismissed right away. So if this goes past an immediate dismissal, it'll show how bad the courts are, that they're completely in the pocket of big tech. Hopefully not, because there really is not. This is not a good. But notice all of the law Twitter that likes to yip away whenever they don't like a claim being made against big tech is suddenly silent when a really frivolous lawsuit is being filed, like Twitter is filing against the state of Texas.
It was so. I don't want to say it's frivolous because you never know how a judge is going to go on it, but it is drafted so poorly, and they say things in it which seem damning. Like they say things in it in that they have First Amendment rights, and they purport to be a platform benefiting from immunity, while now it's not just a question of them conforming to the criteria of Section 230. They're basically saying their First Amendment rights trump the First Amendment rights of everyone who's using their platform. And so it's no longer a question of complying with illegal or obscene or lascivious content. It's First Amendment protection now. And so they are effectively admitting that their moderation or their what's the word? Their censorship is in fact not at all even grounded or anchored in Section 230. It's a First Amendment issue. They benefit from it, and therefore no one can impede them from doing it, which is an undermining argument as far as I'm concerned. But then to go into the, to say that we have no bias, but then we systematically censor big names on the right because we determine that they are a threat. They're undermining their arguments on the 230 side, and they're also making it look like they are editorializing to the point of being a newspaper and not being
no doubt about it. I mean, basically it's their King Kong, and they want the courts to let the state of Texas know that they're King Kong, and hopefully the courts will recognize that's not who they are and what they are, but we'll find out.
And we got Jasper Jones, who says, I sure appreciate the legal analysis, but I wonder if we might all do well to have a brief moment of silence and recognition for the egregious lies, fraud, and injustice that seems so apparent against American citizens. I'm going to publish a vlog after this stream on an article, a tweet sent out by Robert B. Reich, referencing an article, which is another hit piece on Elon Musk, about how hundreds of cases of COVID arose in his Tesla facility in Alameda County. Hundreds of cases. And when you dive into it, it's hundreds of cases over 7 months in a factory that in a factory that employs 10,000 people. And I don't want to spoil the punchline of my vlog. That's 4.5% infection rate. Take a guess as to what Alameda County aggregate infection rate is, what California infection rate is, and what the United States infection rate is in that order. But watch the video afterwards, and then we're all going to tweet it out to Elon Musk. Okay, there's one subject that you have that I don't know anything about, and it's our Arkansas abortion law. And I know nothing about it. So what's the deal? What's the deal?
Basically, Arkansas has passed almost a complete ban on abortion, with their objective being to challenge Roe v. Wade at the U.S. Supreme Court. And the belief is in the pro-life community that the 3 Trump justices combined with the 3 Trump appointees combined with Alito and Thomas are 5 votes to overturn Roe v. Wade. And so the question is whether that will be the case. It likely will reach the U.S. Supreme Court. The U.S. Supreme Court has kind of dodged the issue and, it kind of affirmed it, but not fully affirmed it over the past 40 years. There's skeptics would say that this is optimistic on the pro-life community side, but we'll find out.
Full ban?
Yes, almost a full ban. I mean, very limited exceptions, is my understanding. Okay. So and that's their goal. Their goal is the belief in the pro-life community is that there are 5 votes on the U.S. Supreme Court to say that abortion can only be limited, or abortion can only be constitutionally protected under much more constrictive circumstances, such as rape, incest, and the life of the mother, but not in other contexts. Some say maybe they'll limit it to different trimesters, etc. The issue, I mean, Roe v. Wade originated, it was not the best Supreme, by even its defenders, it was not a particularly legally genius doctrine, because they mostly dodged the big issue. In my view, there's no doubt that there's a right to privacy in the Constitution. I completely disagree with Bork and others. That's what the Fourth Amendment's all about, fundamentally. And the other rights, even associational rights, speech rights, press rights, petition rights, self-defense rights, due process rights, equal protection rights. I think all of that comes back to some degree of protecting private space and private behavior. So I do believe there's a right of privacy against which the government cannot intrude or interfere or invade. And I have the same position that I have on the question of coerced vaccines, which is it should reach a very high standard before the state can dictate anybody's medical care. And prohibiting abortion is a form of conditioning, limiting someone's medical care. So so I have the same standard. Now, the difference in the abortion context, aside from the fact that a lot of pro-choice people have a completely opposite view on masks and vaccines, all of a sudden then whatever the white lab coat crowd says you have to do, whereas in the abortion context they say my body, my choice. Suddenly when it gets to masks and vaccines,
and just to put out the argument, their argument is going to be the abortion case only affects them. The flip side to that argument is people are going to say, no, it affects another living life, and therefore it doesn't only affect them. But they're going to say, this is my body, my choice. Whereas the virus, the vaccine, etc., affects Granny and everybody else. So it's different enough to create a different standard. Now,
yeah, that's their legal interpretation, no question. But that leads back to Dershowitz's position, which is you have to have a threat to someone else in order to have a pro-choice and pro-vaccine consistent position. You can only say that the vaccine or pro-compelled vaccine issue is that your conduct threatens the health of other people. Notably, a lot of people that are pro-mandate coerced vaccines think it's for your own good, and think they should have the right to do things for your own good, even if it had no benefit or impact on other people. And this is big in COVID context, because right now there's preliminary evidence, or argument at least, that the vaccine may mostly be a therapeutic that's good for you, but not reduce transmission. And so that's where it more directly correlates or corresponds. But the other big difference in the abortion context is or to some degree analogous, is that the life of the other, the failure to completely address when you have two different rights at stake: the right of the individual who wishes to do a medical procedure that they have informed consent to do, versus the right of the unborn life. And the question is, are there any rights of the unborn life? And our law has been all over the place on this. Sometime to this day, we have criminal statutes that consider it murder in certain contexts to cause harm to someone that causes the end of that unborn life. And the real reason for Roe v. Wade was an arrogant deference to doctors' interpretation. It really was not a feminist case. The case is, hey, if doctors say this is good, we're not going to allow the state to interfere with the mighty white lab coats. Not, let's champion the rights of women to control their own bodies and futures and fates. So so I think I would be more comfortable with a decision that fully addresses that question. And then the other secondary question is, to what degree is the court well equipped to do that? Or should this be a decision left to the states? In other words, because they're going to be deciding what rights does an unborn life have. Now, some people have an interpretation that is that we should have life and death determined at the same time period. That we say that as long as there's brain consciousness, we don't consider a person dead. But once the brain is no longer conscious, even if there's blood is flowing and organs are functioning, brain dead is considered dead under most medical terms in the United States. If as soon as there's brain consciousness, that should be seen as a human life with the same due process and equal protection rights of any other human. There's still legal complexities, because there's a feminist interpretation is, could you as a person be taken off the street? Let's say your life was necessary for another person's life. Could you, against your will, be forced to support them for 9 months? And there's an issue there, versus to what degree are you responsible for that life in the first place? Which is some of the moral arguments on this issue. So to me, the legal issue comes down to, does the unborn life have rights? And how do you weigh those rights against the rights of the other individual? And is the Supreme Court the right place to determine this? Because what the Supreme Court could say, they could just affirm Roe v. Wade and its doctrine and strike down the law, period. They could say, say, you know what, we reverse Roe v. Wade. In fact, the unborn life has constitutionally protected rights, and a state cannot allow abortion to occur. Or it could say it's not up for us to really decide. This is the kind of question that is outside of our ken, and it should be determined at the state level. So we're going to say there's no constitutional right to an abortion, but we're also going to say there's no constitutional right to prohibit abortion. They could do any of the three. Of course, they could also wuss out, hide behind the desk, and not take the case. So, we'll see which they do. I, as a lawyer interested in this case, would like to see a lot more clarity than our case law currently provides for. And there are good constitutional arguments on both sides. I have my own opinion about the matter, but it's rooted ultimately in my medical and moral determination of what the value of that unborn life is. The question is whether a court is the right. Is the U.S. Supreme Court the right people to make that determination? And honestly, I have doubts about that. I can make an argument both ways.
Okay, well, we'll see where that goes. There's certain issues I stay away from. This is one of them, because first of all, I know what I believe. You're never going to change anybody's opinion on either side, and it just if politics creates toxicity, this particular issue is too impassioned on both sides. But we'll dissect it and see where the courts go with it in due time. Do we want to talk about James, the pastor in Quebec, in Alberta, who was jailed? I mean, it will not be news for anybody who saw the live stream last Thursday with John Carpe, but bringing it back to Canada and talking about what's going on here, in addition to the never-ending lockdown issues in Ontario, in Quebec, and the rest of Canada. There's a pastor in Edmonton, Alberta, or just outside of Edmonton, but in Alberta, who is now sitting in jail because he was issued 2 infractions for violating the health ordinances as relates to maximum occupancy of his church, which he was hosting. He was not turning people back. He was not respecting social distancing guidelines. The plexiglass cubicles, maximum occupancy of 15% ordinary occupancy. Gets 2 tickets, gets released on bail conditions that he does not sign, which is one of the arguments. Continues to breach the orders and is told to come back to the police station, goes in himself and is basically incarcerated because he refuses to sign the bail terms, which would compel him not to host services that are not in conformity with the health ordinances. And his argument was that he is unable to comply with those terms and therefore is not going to undertake to do it because his religious belief requires him to hold services in person, and not turn people away. And his trial scheduled for May on 2 infractions, which, from what I understand, themselves cannot end in imprisonment. But because he breached his bail conditions, or the argument goes, that's a criminal provision and not the Health Act provision. So that violation can land him in jail, but the 2 infractions for which he's going to go to trial cannot. And that's the status in Quebec, and that's the status in Alberta, in a province where the premier was apparently, very pro-religion. And and again, it's like sort of brings in both sides of the debate. People are going to say, it's unconscionable that you can hold someone in jail for their religious beliefs. Others are going to say it's not his religious beliefs. He's not following the law. Just follow the law. You have nothing to worry about. Worth noting is that the church apparently did not have any cases, let alone maybe they had 1 or 2 and they shut down for 2 weeks, but no whatsoever. So it's the state of things now, where on paper, by the headline, you have a pastor in jail, and some people are going to say unconscionable, others are going to say just follow the law, you have nothing to worry about. And this is the discourse in Canada now. But
yeah, I mean, it's terrifying that you can use public health as a way to suppress religious expression, such that we're locking up pastors for holding church. This is an insane place we've got to in our society.
Yeah, and I'll bring up this chat here because it's the abortion question is very personal to a bunch of people. Dave Rubin in his book set out his position, and it's an entirely reasonable position. And yet I can still understand people disagreeing with his position. But I think where it gets a little nutty is who was it? It was the doctor in Virginia who was giving a radio interview and talked about
That was the governor.
The governor. What's it? Governor
Blackface.
Yeah, but what's his real name? What is his real name, guys? Anyways,
I'm blanking. I just think of him as North. I can see him talking about a certain famous Austin Texan does a very good imitation of him. But it's frightening. It really the moral emotive issue relates to how you see the unborn life.
North of
one of the great myths out there is that this is a women-men dispute. It really isn't. Both pro-life and pro-choice activists are overwhelmingly women, and that's true of the pro-life side as well. And it's because of their focus is on that they see an unborn life that's being unprotected, and that's the most vulnerable life in the world, really, from a human life perspective. And do we have a duty to constitutionally protect it or not? And if we do, how do we weight that against other people's constitutional interest? And our Supreme Court has mostly dodged it while going with whatever is cool and chic in deference to the medical establishment. And that I've never agreed with. The question is what the solution is, and there's a fair debate and discussion to be had, I believe. But yeah, it's an issue that triggers a lot of deep emotions for good reason. No,
for sure. When you hear someone like Ralph Northam saying what he said and then trying to walk it back, and the thing that I found the most eye-opening for me, and it's not anything I'll ever discuss here, but the market that gets created for the remains. And when I found out about that, because I these are the types of things which you think are conspiracy theories growing up, and then when you realize that demand creates a market, and when you have a market, and when money becomes an issue, corruption ensues, and corruption on an issue like this is a horror that is unimaginable. So,
and look at what happened to the 2 undercover reporters who disclosed it. That they're facing criminal charges, civil suits, everything known to man. California's throwing the book at them. And there's been this false narrative that they put out fake news, just like the false narrative around James O'Keefe and Project Veritas. No, they didn't. I tracked that case. What they accused those people of doing is exactly what they were doing. There were follow-up fines, a whole bunch of actions taken against them by various state actors, including in Orange County. People can look that up for themselves. But yeah, deeply disturbing what that world is like. I mean, I always go back to a conversation I had with someone from Planned Parenthood when I was a kid at Yale. We formed a group, a society of conversation society, me and 2 others. One of them was the daughter of Justice Breyer. And we did a discussion about population and whatnot. I didn't know anything about Planned Parenthood at the time. Sat down to, I think he was the number 2 guy, and the conversation what I had with him changed my opinion very quickly. Well, it made it clear I didn't have an opinion, but I learned never to trust that organization ever again. They make let's just say it was a deeply disturbing what not only he believed, but he assumed I would agree with. So it's a problem.
Everyone out there should go just do a little looking into it for yourself, and you'll maybe learn things that you didn't know that might change the way you view the things that you thought you understood. On that, Patrick Crocker says 9,500 watching, only 2,000 likes. Come on, everybody, hit the like. It's an opportunity. It's an hour and a half in. Hit the like button so that it does what it does. But thank you very much for the support. And we got Ralph Northam, the post. Okay, the post birth milk. I mean, I don't. It's. If anybody does not know what Ralph Northam said, go listen to it. Another thing that will just...
Well, it's still available out there because who knows? It'll be another one of those things that disappears down a memory hole of social media censorship. That's why we created the Locals page, so it's always available and always free of that censorship if people want to check it out. VivaBarnesLaw.locals.com.
Now we got what's going on with Tucker versus the Pentagon. Is there any legal action if the military is smearing a citizen? Okay, good. This is good. This was not on our menu, but let's talk about this. First of all, occasionally I make a tweet that I feel bad for afterwards. Now I read. So for anybody who doesn't know, there's this military guy. I mean, what's his name? His name was not on the Twitter account, but Tucker Carlson did a piece criticizing Biden's speech where he's talking about how progressive the U.S. military is, that they are having form-fitting pregnancy aviation suits for women, uniform issues, other things, and hairstyles. That was the one that struck me because I was discussing with my wife, and she said, "Well, I said, well, maybe they're not going to be flying, but maybe they want to show up to work when they're pregnant, and they have to dress in the attire, so makes sense." The hairstyles was where he says we're celebrating in the U.S. military the progressive and inclusive nature of the military, and we're updating our hairstyle protocol. And Tucker basically says, you have China and military adversaries watching this, and they're probably having a field day laughing. Then you had this guy. Someone can give me not his name, but his Twitter feed. And it's not a question of putting him on blast anymore. But this guy in his military uniform, in his military office, from his military account, criticizing Tucker Carlson, an independent journalist, and social media went nuts. Poso, Cerno, Posobiec, Cernovich, everybody. It was like, okay, you now have the military, taking political aim at the media. And then I tweeted out a couple of tweets that I feel guilty about because they could be hurtful. But I reached out to see if he would do an interview, and it might not be happening. But I said it's because the discussion is there. But what I said is, this military guy comes out and criticizes Tucker Carlson, says Tucker Carlson has never served a day in his life. I've been in the military for 28 years, and what we're doing is actually empowering and strengthening the military. Whether or not you agree with that, that's a question of opinion. To say that Tucker Carlson's opinion is invalid because he never served a day, and I said, wow, so this guy's saying that Tucker Carlson can't comment on the military because he has never served a day in his life, while this guy comments on pregnancy, despite, I suspect, having never been pregnant in his life. This is not how, this is lacking insight. And I felt guilty about it. And then I also made a reference that he had an odd hand gesture which the ADL has classified as hate speech, which I said, if we're going to live in an absurd time, look what he did in this video, social media, it was to illustrate the absurdity of the times and not to actually make an accusation, but I felt guilty. But Robert, so what could be any sanctions? I mean, would it be employment, military protocol that you're not supposed to do this from an official account? Is there any sanction possible whatsoever?
Not that I know of. I mean, the military has broad-ranging rules, so they can always do whatever they want internally. But generally, almost all executive officers are immune from defamation and libel because of the Westfall Act. And that wasn't supposed to be extended to members of Congress, but that's what we were up to the U.S. Supreme Court about on the behest of the Covington kids. But it's usually usually it's tough to sue them. And he didn't say anything false; he just had a different opinion. And it's probably not a good pattern that military people being too critical of members of the press. But as a whole, I understood people being upset about it. I was not. I thought that was fair game. Tucker doesn't mind. Tucker likes a good debate as much as anybody. So I thought that was and I thought his point was a fair point, that you see a very different mindset from China than the U.S. particularly as it approaches wokeism and in the gender context. And the idea of having pregnant women actually serving, I think, unsettles probably many Americans because they take a sort of protective position toward that life and so on and so forth. And but right now the ACLU is on the side of forcing women to participate in the draft. So we're seeing a lot of things I never thought possible.
Joking hashtags becoming reality. I mean, it's madness. No, I said the first of all, I thought the military guy, it was not over the top. It was not egregious. The reaction I mentioned to them is they probably had no idea that they were going to get such a reaction. But the idea of having pregnancy aviation suits, I don't understand the context in which they would be used. So other than virtue signaling, the progressive nature of the military, which I think arguably could undermine it as a threat to foreign powers. If you do it, good. There's nothing wrong with it. But to publicize it on a national scale could cause it, Russia and China, so the military powers, to potentially not take it quite so seriously. And my wife said, yeah, okay, so they have an aviation suit fit for a pregnant woman. It's like, we have teachers in our family who are not allowed to teach in the last few months of their pregnancy for pregnancy issues. Nobody's flying a plane. So these really are gesture issues and not anything that in any material sense is actually going to strengthen the army. So I think Tucker's point is fine. The guy's response was fine, but the backlash against the guy, I mean, I don't like anybody making fun of his weight. Like that was one thing I just, look at this guy. He's in the military. I've never seen someone with a physique like that. That's not fair game. That's stupid game. But the rest of it, the logical fallacy of him saying Tucker Carlson's opinion is invalid because he hasn't experienced it yet while talking about pregnancy, I found that ironic. But yeah.
And I think mostly the bigger concern is the military going woke completely. I think that's the real concern. Them doing political purges of people who have dissident opinions, them trying to create a politically uniform and military, not so much their color or style or gender conforming nature of their uniforms, but of having a uniform political ideology that celebrates wokeism, I think is the broader social cultural issue, but it probably will only show up legally internally, where soldiers have either because there's discipline or because soldiers contest that kind of discipline that's taking place. I think that's where it's likely to show up in the courtroom.
All right, we got this here. Timing's good. Watching regularly has me wishing I went to law school when I got my BA at 51 years old in 2017. Love the shirt and tie vest combo, Robert. Thank you very much. And then we see here, flight suits in the military have become like participation awards. The Air Force is the one service where officers do the fighting. Not everyone needs a flight suit, but fire-resistant uniforms, okay.
Well, and that bridges to another topic. We're going around lecturing, Russia, lecturing other governments around the world, lecturing Bolivia, lecturing other governments about Venezuela, what they can and can't do in terms of their process. They're saying how terrible it is that they're seeing what they interpret as criminal prosecution of their political opponents, while the same Biden Department of Justice is doing the most aggressive targeting of their political opponents of any of those governments. Much more so than what's taking place in Russia, much more so than what's taking place in Bolivia. I mean, Bolivia was an actual coup that the person's being criminally prosecuted for. In Russia, it's clearly, the Navalny's a spook back guy. He's not a legit. He has approval rating around 1% in Russia. It's solely a story meant to destabilize the country. While the United States, completely without any degree, just like Twitter's case against Texas, just like this military guy on Twitter, completely out of context with understanding the world, while they're aggressively bringing criminal prosecutions against anybody who was anywhere near the Capitol on January 6th and denying them bail in violation of their 8th Amendment rights, often violating their 5th Amendment due process rights, but now violating, in some cases, their First Amendment rights of the way information was searched or why they are targeted. Sometimes they're bringing huge SWAT teams in. I mean, just lunatic, pretending these people are something that everybody in the world knows they're not. And it partially got exposed and blown up this week in court in two ways. One, the prosecution ran to indict, ran to imprison, and unlike the way the criminal process is supposed to work, they did so without having much evidence. And now, even though there's a constitutional right to a speedy trial under the 6th Amendment to the U.S. Constitution and a right to a speedy trial that is confirmed by laws passed by Congress, which says basically you're supposed to get to trial within 70 days of your first appearance, the government's going in begging courts to keep these people imprisoned while they just keep delaying the trial because they don't have any of the evidence that they were claiming they had.
What did they say? They said it was going to be the most complex investigation in U.S. history.
It's hard when you're trying to fabricate evidence. It's hard when you're trying to gaslight the world.
No, but like the thing is, I don't like making the comparison to 9/11 because it cheapens 9/11 and it almost adds some credibility to this Capitol riot that it does not deserve, even by being associated in the same sentence. But it's the tactic by the media that they use. Keep saying them together, and people will attribute the same importance to them. The 9/11, I can imagine being the most complex investigation ever. The Capitol riots, we saw it in real time. There were some tragic consequences, by and large, from Ashley Babbitt, not from Sicknick, who arguably now is updated his status to possibly have died from a stroke, and they're investigating whether or not it might have been induced by pepper spray, and 3 other medical emergencies. People say the strokes might have been induced by some trauma. Yeah, fine. But to refer to the Capitol Hill as the most complex investigation ever is Parkinson's law of politics again. They want to focus the time on this, and they want to make it into something it's not. And so they keep repeating the same thing over and over again, and maybe people will start to believe it. It's nonsense. And for what's going on there compared to what's going on with the Portland rioters who assaulted officers, who are being, having their charges dropped with prejudice, while these other people are not even being able to post bail, it's egregious.
Yep, and it's getting worse. And so what also broke in court this week was one of the people they're trying to accuse of being the big orchestrator, co-conspirator, talking to Trump people. It turns out they've got zero evidence of any of that they don't have any evidence that he organized anything, that he planned anything, that he premeditated it. They have zero. And for folks that don't know, they have carpet bombed the amount of, in terms of getting evidence. They've seized every email, every phone call, every text. They used every trick in the book to gather and gain information. And the fact they're at this stage without any of this evidence proves that they've been lying all along, that all that happened was a few people broke the rules because at a sort of instantaneous moment. And you can figure out whether, sometimes cases are complex because they're trying to cover up what really happened, not expose what really happened. So it's intriguing how they get complex in certain ways. But that's a future hush hush episode on vivabarneslaw.locals.com. But so people, and we can go into what we can't talk about on YouTube. But there's no question that they don't really have the evidence. And in my view, they're violating Speedy Trial Acts. Now, the Speedy Trial, basically, if there's compelling cause and there's all these provisions, you can get around it. But usually when the defendant objects, you're under major pressure to make sure it happens within that time frame when it's already been statutorily set at 70 days, as it is in a federal case. And particularly, in my view, what it also implicates is due process and bail, because at some point you continue to imprison someone while asking for more and more time for trial, even though most of these people are being imprisoned pending trial for a longer period of time than the sentencing guidelines would ever allow them to actually be sentenced for.
That's the most shocking thing. And the tactic there, Robert, if I've learned anything, and I've learned a lot, it would be give them the prospect of staying in jail for longer than the sentence would be, get them to plead guilty, and then you get your political victory.
And they need some people to fake a story. They're probably willing to give people real sweetheart deals if they'll fake a story. Oh, I talked to so-and-so, and then we talked about it 3 days in advance, and stuff that can't be disproven technologically. When does the government need a continuance? When the government doesn't have the evidence, or when they need to manufacture it.
Now, I want to bring up one chat which I can no longer bring up, and it comes from Jasper Jones. I brought it up a minute ago, but there is no way that you both can discuss this every week without mental and physical ramifications. I hope you both take care of yourselves. We need you. I know this is selfish of me to say. Seriously, my heart is with you. There are some mental ramifications. It took me 10 minutes to remember what I wanted to talk about. Flynn. I'm going to get to it. There's other. The only real ramification is that, Robert, you're still optimistic. I feel like I have seen things now that cannot be unseen, and it is the perspective through which I view the world. And I feel bad for anybody who just goes about their business with gleeful bliss, and yet also envious, because if I could turn off the switch, I'm not sure that I would, but the thought is there. Seeing how things are fundamentally corrupt. On the one hand, it deters any reasonable person from getting into politics. It deters any reasonable person from getting into law. Same people who keep asking me, file lawsuits. I know what I think of how the system works, and I think I'm not going to say rigged against people. I just know how it works. Now I'm just trying to figure out what the solution is. But mental ramifications, physical, I exercise. I mean, I take out my energy on the treadmill. But yeah, the mental ramifications, there's too much going on in my head. Robert sends me emails, and I've got homework, like as of Wednesday, and there was a lot of it this week. But one that was not on our list, and I want to bring it up, it won't be too long. Flynn. They're going after Flynn again. And, the questions I had, so for anybody who knows now, Flynn has been pardoned, but the what is it, Department of Defense, or the Defense Watchdog? I don't know I didn't know you have watchdogs in the military who go after potential ethics violations, and they've investigated Flynn. They started the investigation in 2017. It was suspended and magically reopened relatively recently, and then magically closed a week into Biden's presidency. And they've submitted their recommendation, or the file, to the military, to the army now, that is going to determine how to proceed. And the question is whether or not Flynn violated the emoluments clause by getting paid gigs through Russia and Turkey while he was a pensioner in the military, and he's not allowed apparently under the emoluments clause. Despite the fact that he apparently notified the army that he was going to be doing what he was doing at the time, his attorneys ought to have filed the proper paperwork to allow for it, because it was not concealed information at the time. And now, having been pardoned after this ordeal before Judge Sullivan, now they're going after him for a disciplinary civil sort of matter that is not covered by the pardon, which might result in him having to pay back the $10,000 a month pension he received from the military for the time he was paid for doing other work. Where does it end? I mean, where does it end?
Well, I mean, two things with it. One is I don't think this is a violation of the emoluments clause. I think it's a crazy and absurd. The emoluments clause was put in there to prevent a diplomat or State Department official from being bought off by European royalty and secretly working, like saying, hey, a French king will make you a duke as long as you give us Louisiana you use your U.S. position to do so. That's what it was for. It has no application in the way that it's being applied today. Now, this is an interpretation of the emoluments clause, so really his problem isn't the emoluments clause, it's the Defense Department's internal rules, which they have applied completely inconsistently. So, I mean, the current Secretary of Defense sat on the board of Raytheon. All these people make tons of money from you could track back to foreign governments, either foreign governments buying the products of the companies they sit on, or investing in those companies one way or another. So I have problems with it, with its completely joke of an application. The third problem is I don't think Flynn violated it. Flynn was not hired by the Turkish government. That not an issue. And he told them before, the Russian government honorarium that where he got paid to go over and be at this event, that was an inside deal. He was told that the Defense Department asked him to do so he could get inside information and bring it back, which is what he did. So he had to take the payment because otherwise it would be obvious what he was doing. Though I'm sure Putin's people knew exactly what Flynn was doing. But to keep up the ruse. So the idea that either one of these was somehow secretly working, the way the Washington Post wrote the story was so deliberately misleading.
No, it was over the top. And the other thing is, the emoluments clause, I understand as applying, even if it applies. My understanding is it would apply when you're in the position of government, not afterwards, because there's no risk of influencing your political decisions through bribery or the international bribery if you're out of office as a retiree operating a totally indistinct business. But I don't even understand how it applies in the first place. But it's just a question of finding a way to go after Flynn. And people are saying, like, what does he possibly know? What could possibly be the motivation to continue with this?
That right there. It's further proof that he offended and upset the deep state just by being independent of mind. He didn't set out to do so, but he was civilly targeted. There was a leak campaign against him, then criminally targeted. Then the judicial system came after him. Everybody's come after him. And then I think, people can watch on a Hush Hush episode, I think QAnon community deliberately targeted him for misinformation and disinformation to discredit him because he stumbled across it. I represented people connected to him. That anybody that he suggested would be a good person within the Trump administration was blacklisted or blackballed and was put under criminal investigation by Mueller's team or civil investigation by their relevant department and made clear that they better keep their head low or it was going to get chopped off. And it's just because he's an independent guy. I mean, I disagree with Flynn on a wide range of issues and strategic issues that he's been on different sides over the past. But what he was independent. He was independent of mind, willing to raise questions, came from a blue-collar background, and consequently, because he offended those deep state boys, that's why it shows you what they will do. And they want to continue to make an example out of him so no one ever thinks about sticking their head up again. They want to solve their Snowden problem permanently. You stick your head up like Julian Assange, you stick your head up like Ed Snowden, you stick your head up like General Flynn, and the whole weight of the system will come to crush you. And the message isn't just so much to them, it's to anyone else who gets that same idea in their head.
That's the other thing is, I wonder in Canada if the political game is quite as dirty. I have no doubt it is, but people say, well, go run for office. But tabarouette, can you imagine working in this environment with the people that you're working with and the dirt that goes on? The thing I found most eye-opening was, you talking about the FBI, not the FBI, the JFK assassination and the dirt that they had on Hoover and things that they can use for blackmailing. What do they do with people who don't have dirt on them for blackmailing? Like, what means do they then use for coercion? But
multiple levels. In fact, this week there'll be a Tuesday Hush Hush episode every Tuesday starting this week, and then every Thursday starting this week will be deep episodes called the Deep State, going into some of that history. But Flynn is a classic example of the problems with this system and how out of control it has become.
All right, we have let's say 10 minutes left before we get over the 2-hour mark. More gun control laws. That was one of the topics. Also, the
ones that passed this week were not that big, but they're problematic. But nowhere. What is their extent? They're extending the reach of background checks and extending the length of time the background checks can go on. I suggested back during the peak of the lockdowns, said, watch, they're going to suspend people's Second Amendment rights indirectly by just never getting around to clearing somebody for a background check. And they're already starting to go in that direction. They want to make it longer and longer and longer. And that way you could just functionally deny someone their Second Amendment rights. Imagine you're in an emergency situation and you have, because the background checks can be done immediately these days. That's where the technology is. So, but imagine, let's say you have an ex or someone else that's threatening you and you need to be able to defend yourself tonight. Well, you can't go get a gun because they're going to extend it to 10 days. And so instead of being able to get it right then, you got to wait forever. And there were places you could go and get them quicker. They're removing all those too. Now, whether it gets through the Senate filibuster, an open question. But would it be constitutional at this point? Probably so. But at some point, it becomes so intrusive that it functionally denies someone their Second Amendment rights. There's some good organizations looking at what suits they can bring. But clearly, the path they're going on is perilous for being able to have meaningful self-defense in this country if these laws all pass.
I undoubtedly suspect that it's having an impact on sales now, which I guess it's going to, the more of these potential laws that come into effect, increase in sales in the short term, which is totally counterproductive, but it seems to happen every few years.
Oh, it's smart. I mean, it's smart. You want to be able to have something before you need it, not have it when you do need it. And so it's a good time to be able to be prepared and protect yourself because these laws and restrictions, they're going to try at least in a lot of places, and it's a problem.
All right. And do we do questions from locals? Do we have any?
Yeah. One other topic, sort of the law and culture series, we're going to start little segments we'll do on each week. The Toddy Westbrook case, big YouTuber, has sued another YouTuber. I think it's Without a Crystal Ball, something like that.
Yep.
Who for defamation. There's a big personal jurisdiction issue. But if you want to see what a nightmare law looks like as a soap opera, follow this crazy case. And so it is just one. It's why I hate state courts. These lawyers, I bet, do a lot of state court litigation. This federal court judge is going to hate him if she doesn't already hate him. I think it's she. Because they're doing the kind of game. It's all drama. We're going to file this motion, file another motion, file a motion on the motion on the motion, and then file that motion on that motion on the other motion on that motion. I mean, just paperwork, killing trees like crazy up there. And but my favorite one is it's like a form of motion to include. I forget what he called it, motion to qualify, which I have never seen before in history. So you're a lawyer, you're admitted into the case, and someone can move to disqualify you, but that's limited. Just because you may have a conflict of interest doesn't mean the other side has standing to raise the question. But has filed a motion to qualify. They've already appeared in the case, and they want an advance motion on a possible motion to disqualify that hasn't even been filed by a motion to qualify me, Judge, which I have never seen in my life. It is a crock. It is a joke. It is an embarrassment. And what the lawyers are doing in that case continues to be an embarrassment to the practice of law.
I was going to say, Uncivil Law has been covering it extensively and remorselessly. Yes. Nate Brody's been covering it as well. I've stayed away from it. I stayed away from the Tati story when it first broke out with James Charles, because I said, look, I think I've got a pretty good sixth sense when it comes to these things. I said, I don't want to get involved even in an analytical perspective with any of the players in this, because I think that they are all weighing my words.
Mentioned. If you comment on the suit, you somehow get mentioned. So I think Nate's shown up in it. Erica Baker, I think, is shown up in it. I think it's Erica Baker.
I got the feeling from the beginning that this was the parties in this were the type of clients you would not take as a lawyer. And my goodness, has it turned out to be the case? Forgetting what Tati did with James Charles, which ended up being nothing but the most outrageous smear campaign, smear campaign out there, which I suspected at the time. And I said I didn't want to get into it because it involves reading intentions. What's going on in this lawsuit, above and beyond all the questionable law, the threats that are going out from one party to the other party and between lawyers and the parties are basically admitting to sicking their social media crowd on the other, and it's gone over the top. So it's drama for the sake of drama if anybody wants to follow it. But yeah, uncivil law.
I think the federal court will dismiss it for personal jurisdiction grounds, solely because she doesn't want to see this case ever again, doesn't want to see these lawyers ever again.
It is nuts. You'll get more of a thorough, in-depth analysis on uncivil law and Kurt Mueller and Nate Brody. But it's we do the analytical stuff, the real legal questions. This is Jerry Springer type drama of what does the law look like if Jerry Springer directed the court? That's what this is. By the way, Jerry Springer used to be a good personal injury lawyer back in the day. Well, I have no doubt he is charismatic to some extent.
Oh yes. He has created a crazy show. But yeah, first question from locals was Potter 89. Does the military occupation of DC violate our right to petition? Probably not at this juncture. That's the right that Justice Barrett forgot about when she was asked about in the Senate. She's like, oh, there's 5 rights in the First Amendment? What a promising sign that was. But at this point, probably not, but at some point it is. These are public places, public spaces. Generally, the courts have not really enforced the right to petition except in a limited way. They've said you have a right to send a letter, but not a right to an answer, not a right to send a letter in a particular way, not the right to petition in a certain way. So the scope and scale to which that right is enforceable is an open question. But at some point, continued military occupation of the nation's capital does raise constitutional questions. The second question was from Service Crick about compelled vaccines. Watch my debate with Alan Dershowitz, and that lays out what I believe the constitutional constrictions are and evidentiary limitations are on compelled vaccines. And in my view, the evidence has not yet been presented to persuade, I don't think would persuade a judge, jury, and legislature combined. I think all three need to be involved, and all three need to approve and assent for any vaccine to be compelled. When it's being done by the private sector is going to raise a separate set of questions, a HIPAA set of questions. They're probably going to put in exceptions that appears in some cases they already have to allow this to be outside of HIPAA protection. So then it will go to Fourth Amendment privacy right constitutional issues as to whether or not that HIPAA limitation created a state-sanctioned invasion of of various forms of privacy. There's also already existing laws on the books that protect religious exemptions and other things. Right now, it's not a state-driven issue. It may become a private sector-driven issue, and that's going to be trickier. In my view, it's more argument for allowing, for limiting the ability to fire people except for cause, which I've long believed. And even though that's seen as a left-leaning position, I believe it has right-leaning implications in the current environment. Couldn't be fired for what you post on social media. Couldn't be fired for your free speech. Couldn't be fired because you don't want to take a particular invasive form of medication. My view all the way through is we should apply the Nuremberg principles to everybody, public and private, which means nothing can be done that isn't informed consent. And there's a question about whether these things are informed consent. If employer is providing it, they may be committing the tort of informed consent, but I'm still legally researching that question.
And I do want to point out, like, there are new faces here, which is great, who ask questions like, you know, what do you think of this? And Robert and I have talked about it extensively. So Robert did a debate with Dershowitz on the forced vaccine question. It might have been more of a love fest than an anger debate fest, because I think Robert sort of compelled Alan to recognize that they basically agree on the main points. But go watch that for the full, if you want a full thing. Another question we always get is airlines, face masks, and we've talked about that a bunch of times. And actually, good time to mention it, I just covered Robert's lawsuit on the Americans with Disabilities Act claim about a plaintiff who was kicked out of a Lazy Acres grocery store and was forced to wear a mask for treatment at a health center. So we're going to see where this is going, but these are issues we've talked about in the past. Some people ask, it's not the first time, so we can't repeat it every week. Just a heads up if I don't get to those questions when you ask them.
Absolutely. From Bald Man, interesting name. Is there any consequence if it turns out Joe Biden's health was hidden from the public? Not really. Other than the 25th Amendment, if he truly became non-functional, inability to do it, I don't like the abuse of the 25th Amendment. So it needs to really be clear that's the case. That's the only constitutional remedy. There is no, even if somebody lies to you to get elected, that there's no constitutional remedy for that. Not even impeachment. Woodrow Wilson in 1916 got elected because he kept us out of war. Within 2 months, we were in World War I. So that's the nature of the political.
And another question, we've talked about it at length. Even if the most decisive evidence of whatever came down, at this point, there's no undoing the election. There's no holding it again. It's impeachment, and Kamala Harris gets bumped up the totem pole. Exactly.
Question number 4 was from Shavetail about why I don't like Ben Shapiro, or not a big fan. I don't dislike Ben Shapiro. I just don't think he's a trustworthy source on certain political issues and legal issues. He's anti-populist. Best way to sum up Ben Shapiro is, other than his wife's a doctor, he'd let you know that, is that he was never Trump. And he advised people not to vote for Trump in 2016, which, if his effort had been successful, Hillary Clinton would have been elected president. So ask yourself if that's someone whose advice and analysis you trust. That's my view. We'd be happy to have him on and happy to debate him about any and every topic.
Well, that's the thing. A lot of people are more sensitive. I tend to think that we're all adults, and even if you say something that other people find offensive and make fun of Ben, whatever, it's fair game when you're, to some extent, Shapiro doesn't hide his making fun of other people. So if you can dish it out, you can deal with it, and even if you can't, you still should be able to deal with it. People take it more personally. I think it's fair game. I would have Ben Shapiro on. I would be on with Ben. I just don't know enough about Ben. I it would be more exploratory for me and not confrontational. But maybe we have a Barnes versus Shapiro fight night on Viva Fry.
Yeah, that'd be fine by me. And the last question was from 17 Tactical, the intersection of federal preemption and the 10th Amendment. It's actually a very, very good question. It gets real complicated because at what level does the feds pass a law that they have authority to pass that in turn that prevents states from enacting laws on that subject matter that in turn raise questions under the 10th Amendment? It starts off with the fundamental question of whether the feds had the right in the first place. So does it fit under the Commerce Clause jurisdiction? Does it fit under other areas that the feds have the right to? If that's the case, then federal law preempts state law regardless of the 10th Amendment. But the 10th Amendment is considered part of that original analysis about whether it's federal power in the first place. For the most part, the Supreme Court has not been the strongest enforcer of the 10th Amendment, which is an understatement, ever since, frankly, the Civil War kind of resolved that question politically, even though it didn't, in my view, constitutionally. But that's the effective scope of it. But it gets into a lot of intellectual complexity as to how that intersection works. So it's a great question, which I can only give a abbreviated answer for.
All right. And now I'm not going to answer this question because apparently even discussing this type of issue on a YouTube channel can get a video in trouble. It's my,
yes.
It's back
I
in
can have it. But some people get upset if it's lit, and YouTube has taken an anti-tobacco position. So I myself would never recommend a very nice particular tobacco.
No, it's nuts. I know that my video on the Schwarzenegger lockdown was demonetized because I made a joke with a pine cone substituting for a cigar. All right, I think we've done darn good. We've covered a ton of material. I think we left a few things off the table, but it's good to leave some material for next week. Wednesday of next week, I'm going to go reach out to Gad Sad on Twitter and see if I can DM him as a local Montrealer. Maybe we can even do it in person, sitting 2 meters apart. I've got the long enough mic pole. So we'll see who we're getting for Wednesday. The rest of it, when are we getting Doomcock on?
So a week from Wednesday will be Nerdrotic. 2 weeks from Wednesday will be Doomcock. 3 weeks from Wednesday will be Jack Murphy. 4 weeks will probably be Elijah Schaefer. After that will be JD Vance. And we have about a dozen people who have committed to come on the show and talk all the way through the summer. So it's going to be a lot of fun.
It's going to be amazing. People accuse me, and I guess you by extension, but people accuse me of only having right-wing people on. I don't know that I consider you right-wing.
We will have Michael Tracy on, who's a lefty journalist, yes. And we'll try to get more of those people. The reality is the left generally doesn't want to. Hey, if I was in the left, I wouldn't debate me.
No, there's no question. And the left doesn't, they get, I find, I don't want to generalize, but, are much more of, you got to shut the comment section down. I don't want to see bad comments. It's like, well, I can't do that. So if that's a precondition, it's a non-condition. There's some people out here making fun of you, Robert. Like you deal with it and you ignore it, or you.
Well, contrast it like with Cernovich. He includes people's negative comments and retweets them out just for fun or puts them on Instagram. So there's people who engage and have fun with critics, and there's those who just don't handle them well. Tracy's always been open game that doesn't care. So and we're hoping to get those. Aaron Mate would be great. There's some people that I know internationally that are more aligned or at least partially aligned with the left, but there's a time gap there. So we're going to continue to get fun and interesting people on every Wednesday, and then we'll continue to have exclusive content at vivabarneslaw.locals.com. And if you want to troll me, that's where you got to go.
So everybody, thank you very much. By the way, I am going to reach out to David Packman again. I can't reach out to the doctor who blocked me because I said that's one heck of a way of admitting your initial projection was wrong. I would love to have Stelter on. Would that be glorious? And I'm still going to push for Sarah Silverman. If she claims to have had the position that she has had, I know that we are who we are, but we might be insignificant to Sarah Silverman. But I would like to have her on because I have my issues with her. I have my pros with her. And if her revelation is indeed a bona fide revelation, she should have the discussion. We'll see. But in all that said, people, thank you all for tuning in. Thank you for the continued support. Thank you for making this what it is, because it's snowballing, but it doesn't snowball without everybody contributing their mass and momentum to this snowball, and it's glorious. Robert, you want to stick around for a
The book behind me is called The Deep State, which is good. It was written a couple of years ago. Not as in-depth as what I go into on at vivabarneslaw.locals.com. And the other one is Intervention by Noam Chomsky, for those people asking that, on interventions. Good short book. Don't always agree with Chomsky, but very informative. Comes from the left, but very intelligent left perspective. So we got our book references in. And for anybody who wants to join the after party, there is a live chat going on at vivabarneslaw.locals.com, top of the page.
And I will try to get there too, but I think I have some kids to put to bed. And a movie reference, Eurovision Song Contest. I made the joke to Cernovich. It's a Will Ferrell movie. It's lighthearted and it has some good music in it. Robert, stick around. We'll say our proper goodbyes. And everybody, enjoy what is